morning, everybody. Welcome to the First District Court of Appeals. We have one case to be argued this morning, which is State v. Lang. Good morning, Mr. Sauter and Mr. Cohen. Mr. Sauter, you may proceed, and as the appellant, how much time would you like to reserve?
Thank you, Judge. 5 minutes, if I could.
5 minutes, absolutely.
May it please the court and counsel. This is a drug and weapon investigation that began with a confidential source telling police that the defendant, Chris Lang, was dealing drugs throughout Hamilton County. Detective Ingram was the head of the investigation here. He began surveillance of 2 addresses in July of 2021. One of those addresses was on Vine Street, where the actual drug trafficking was occurring, and the other one was Lang's residence in Cheviot. Throughout their right around a month and a half investigation, they saw what appeared to be a number of buys at the Vine Street location, and that included 2 controlled buys that they set up with a confidential informant. At the same time, they had a GPS unit that was on the defendant's car, indicating a pattern of movement between the Cheviot address and the Vine Street address, whereby the defendant would leave just about every day around 1:30 to 2 o'clock, go directly from the Cheviot address to the Vine Street address, conduct the drug activity, and then return home.
The affidavit doesn't specify the frequency. I mean, it's kind of vague on like how many times or how many days they witnessed this sort of pattern.
Well, they had the GPS unit, Your Honor, and I think when you look at the affidavit where it indicates the pattern, to me it indicates that it was daily. They've maintained electronic and physical surveillance on him, and that was continual surveillance with the GPS unit. This is on page 7 of the affidavit. That indicates to me that it was daily, but the point's well taken that it could have been a little more explicit on that score. In any event,
and what's the state's position in terms of, like, does this give, if we agreed with the state here, does this give the state kind of carte blanche to always search, to get a warrant, always to search the residence of a suspected drug trafficker? I'm just like,
yeah,
because the trial court was concerned about the lack of any sort of nexus of transactions to that residence.
Right.
And so I'm trying to figure out, like, where would we draw that line?
Yeah, I thought about that too, Judge, and I think the way the courts have come down, and the case law I've cited is from virtually every district in the state and from federal courts, there does have to be some sort of a nexus between the drug activity and the residence, but I think that can be demonstrated by the pattern that was observed in this case. The way the courts have said it is there need not be direct evidence of drug activity to support a warrant for the residence, but there has to be a sufficient nexus. And I think that that's definitely something that the state has demonstrated in this case through the pattern of activity that from the residence to the site of the drug activity and then back.
Counsel, do we know if the defendant went inside of the Vine Street address, or if these transactions occurred inside of that property?
They did occur inside the property. Well, inside and outside. It's on July 14th and July 15th, these were more like drive-up kind of things, where but I think it did indicate that the people got out of the car and went into the address. But in terms of the buy, it appears from the affidavit that it did occur inside the property.
And other than tracking the daily or frequent pattern back and forth between these properties, do we have any specific evidence tying the home to the transactions that occurred?
Well, the confidential source that they had at the very beginning of this indicated where the defendant lived and indicated that he dealt throughout the county. So I think there's some indication of that, but I think the important thing to consider here is that there need not be any evidence of actual transactions at the residence, as long as there's some indication, as long as there's a fair probability that there will be some evidence, and that need not be drugs. It can be records, it can be cash. In this case, it was a lot of currency, firearms, and that sort of thing.
I want to ask you about the Young and Phillips cases that you relied on. In both of those cases, there was actual physical surveillance following the defendant from his residence to what I believe was an outside drug transaction.
Mm-hmm.
Is that similar or different to what we have here?
Well, I think it's even more conclusive in this case because the GPS indicates exactly where he was, and I think that that's indicated in the affidavit that, you know, it's easier to track with a GPS than it would be to follow the guy. So I think it's even a stronger indication of what the pattern was in this case.
And I know that there's something in the affidavit, but I can't recall if anything came up in the hearing, but beyond the going back and forth between the residence and the location where the drug transactions were made, were there other patterns of movement of his vehicle that would suggest, like, he went to this place and, you know, may have gotten, that might have been where his source was or something?
Not that I can recall, Judge. I think that this was his office that he went to every day. It was like a 9-to-5 job for him.
Right.
So if there was some indication of where he got the supply, I don't think that that's in the record, and it wasn't part of the calculus for probable cause in this case. In any event, I think that there's clearly some nexus between the drug activity and the residence in this case. So I think there's clearly probable cause here. There was a fair probability that the place to be searched would contain evidence of a crime. And I think it's beyond dispute that even without the question of probable cause, there was the officers could have reasonably relied on this warrant. The case law is clear from Ohio and from the federal courts that I know that Mr. Cohen doesn't like Leon versus the United States, but it is the law, and there's certainly enough here for a reasonable police officer to have conducted this, to have conducted this search based on the warrant here. And I think warrants hold a special place in the law, and I think that's something that can be that sometimes gets lost in the shuffle. And you have to give due deference to the warrant, and I think that that's something that didn't happen in this case. And even beyond the validity of the warrant, I think it's clear that in this case there was a reasonable reliance on the determination of probable cause that the judge made. Unless there are any further questions, I'll rest.
Great. Thank you.
Thank you.
Mr. Cohen?
Morning, Your Honors.
Morning.
It's kind of strange sitting on this side of the room. Nonetheless, let me start off with the assertion that I don't like Leon. That's not true. I just wish someone would actually read it. Good faith has become the talisman that's always used for laziness. In this instance, they had a confidential source. We always forget there's a reliable portion to that. What we don't have in the search warrant is other movements. The officers only concentrated on the fact that Mr. Lang went from his house to his place of business. Presumably at some point, like any manufacturer or sales operation, there's a supplier. He would have gone somewhere else. He wasn't making cocaine, fentanyl, or heroin in that apartment. It came from somewhere else, but there's none of that.
Yeah, and so that was my question to Mr. Sauter. So did that come up? Was there any kind of cross-examination of the officer at the hearing on the suppression issue?
Just the officer said, we tracked him from the house to that location and then set up surveillance.
Right, and so my question is, did anyone ask him, like, where else did he go?
No.
Okay.
No.
Let me ask, my understanding I don't believe there was a hearing on this, other than, didn't the court rely on the four corners of the search warrant? Maybe I
There
misunderstood.
was argument, there was no testimony.
There was no
okay, I'm sorry.
testimony.
Yeah, there was just essentially what we had in the search warrant.
Let me ask you this, Mr. Cohen. I enjoyed your frankness. I read your arguments, and you essentially admit your client is a drug dealer, but he was going from home to his place of work in St. Bernard every day. Assume that the police thought he was a counterfeiter, and he did the same thing. He'd go from his house, go to Walmart, pass a couple hundred counterfeit bills, go to UDF, do the same, then go to St. Bernard and sell $1,000 packets of counterfeit money for $100. Do you believe there's any nexus between the fact that the police believe he's a counterfeiter? They made buys, and assume they made buys of the counterfeit cash. In that situation, would you argue that the police aren't permitted to conduct a search warrant in Cheviot to look for, paper, plates, printing press, ink, any accoutrements that go along with counterfeiting?
Well, I think you're comparing apples and oranges. We have a situation.
And how so?
Well,
Because there's nothing, he's not selling money out of his house, all right?
no.
All right, so the money, or the counterfeit money is coming from somewhere. The dope's coming from somewhere. And then like clockwork, every day at 1:30 to 3, he goes out to St. Bernard or goes to Walmart and passes the money.
Affidavit doesn't say he goes there every day.
Well, he's established a pattern.
It says they've established, some surveillance where he has gone from the marital home to the place where he makes sales in or outside of the residence. It also indicated that he spent the night there on occasion.
Right.
All right, they didn't set up surveillance all night long. They just indicated he was there at night and he was there in the morning, apparently.
Yeah. I thought there was something in the affidavit of the facts that at one point during one of the controlled buys, your client drove, maybe confabulating, but drove to St. Bernard, was in the car. The buyer shows up, he gets out of this car with the GPS on it, goes in the house and makes the sale. So the dope obviously, he either had it in the house or he had it on his person, but he went inside. How would you address that?
They're just guessing. And there has to be some evidence. It can't just be, if you believe in the Easter Bunny because somebody puts eggs in your front yard, doesn't mean there's really an Easter Bunny. They are going in constantly on officer belief, based on training and their belief. Where is the evidence? And that's the frustration that we have is we're getting rubber stamp search warrants out of municipal court where there's no intellectual application of the laws that exist. And so essentially we have an officer who sets up surveillance. He sees 2 confirmed drug transactions.
Right.
All right. He sees what appears to be drug transactions, or is it Mr. Lang getting drugs from his source? We don't know. We're just at this point guessing. And so in the cases where, good police cases, police officer gets information on a suspect. They then set up surveillance. All right, they have that cooperating witness make contact with the suspect. They observe a controlled buy. But at the same time, at the end of the buy, they follow that suspect back to where he came from. Then the second time, the suspect is contacted by the confidential source. Law enforcement is set up at the house or location where the suspect apparently lives. They then follow that suspect to the point of his sale. There's this hand-to-hand sale. Then that person returns back to that home. One could reasonably conclude that the source of the drugs would be where he came from. And
Well,
they usually do
Mr.
that a couple
Cohen,
times.
wasn't that the case in Young and Phillips, the 2 cases that your opponent relies on, where there was physical surveillance of a defendant leaving his residence, going straight to a drug buy, the drug buy occurs, the defendant goes back home, and the police track all of this, and there's literally nowhere else that the drugs could have come from but the house. Do we have that situation here?
We do not. And that's, in good cases, both state and federal, that's what the courts have looked at. They're looking at that kind of consistency of conduct, which would lead a reasonable inquiry into whether or not the drugs are coming from one place, going to that. Typically, that's an open-air exchange. So, we're going from Green Hills to Surrey Square in Norwood. You've got surveillance set up. You can see there's a hand-to-hand sale. Suspect runs off. informant turns over the drugs. We don't have that here. We have two very low-level controlled buys.
But the controlled buys were, the confidential informant kind of brings this to the authorities. They then set up surveillance. After doing the surveillance for a while, then they engage in the controlled buys to confirm the accuracy of their surveillance. So it seems like they're taking the necessary steps to confirm that this is actually illicit drug transactions.
I don't disagree. But are the drugs coming from the apartment or are they coming from the house?
Well, but how can, isn't this the purpose of the warrant? Like, how can you be absolutely positive? Like, you present that information to the judge and say, this is my probable cause to execute the search.
And they did on Vine Street, found a safe, drugs and a gun. But what evidence did they have at the marital residence? None.
So do you concede that there was probable cause to search the Vine Street address?
Didn't challenge it.
All right.
Absolutely. That was, in my mind, that was good police work. People going inside, coming out, getting their car taken off. Got two pictures attached to the search warrant affidavit where, you see, my client purportedly making a drug sale or could very easily have been making a drug purchase. And there's no evidence.
Let me ask you this. This is a case out of the 4th District, Hobbs, and it's in somebody's brief, and addressing the observation of direct sales from a house. I'm just going to read it to you, Mr. Cohen. Looks like it's quoting State v. Freeman. It says, with respect to search warrants involving drug dealers' residence, an issuing judge may infer that drug traffickers use their homes to store drugs and otherwise further their drug trafficking. A probable cause determination need not therefore be based on an officer's observation of illegal drug activity at or near the residence to be searched. And how would you address that? Because I think in this case, I think it's clear that the police or the officers did not see any drug or what they believe to be drug transactions occurring on St. Martin's Place. And not that we have to follow it, but it is, at least the 4th District thought it was good enough.
I think you answered your own question, Your Honor. I don't run off to the 4th District looking for judicial scholarship. The point is, as the federal law looks at it, which is the Constitution applicable to the states by the 14th, there has to be some evidence.
Well, but going back to your Leon criticism, I think, like, if I were a police officer and I researched the cases and I found the 10th District case that Mr. Souter talked about and the 4th District case Judge Winkler talked about, I would say, this warrant looks legitimate because it's consistent with these cases. So how would that not be kind of good faith reliance here?
I've never known a police officer to do
well, I know, but we hold them
we
hold them accountable for understanding the law. And so I'm saying, like, if they actually went ahead and researched it here, which they probably wouldn't, but if they did and they found these cases.
Well, yeah, I guess if you want to go down that path, but the point in this instance, and I think generally, is we have trained police officers that good faith will cure any infirmity in their investigation, because they will always be able to hold that up. Yeah, they read Leon. They read the good faith portion, but they don't read the 4 exceptions to that good faith. And that's where this sits,
Which exception are you talking about?
Well, one, did the magistrate, or in this case the judge, lose its way because it granted drafted, let me rephrase that. It granted the request for a search warrant based on no evidence that the St. Martin's location would likely be the location of a small quantity of drugs, since we don't have large drug sales. Now, there's a case out of the 6th Circuit, it's Roberts, where court held that, a large-scale drug dealer, somebody, found in a, car with several kilos of drugs in that instance and firearms, that it would be reasonable one might find in his home or his business in that case, additional drugs. If you're looking at the totality of the circumstances, under Illinois versus Gates, this is not that case. You have two very small hand-to-hand sales. You have observation of interaction between my client and others, but again, law enforcement is only guessing that they're drug sales because it has done nothing to confirm that it was a drug sale. It could have been a purchase. It could have been a bookie collecting his gambling earnings, from somebody who lost a bet. We don't know.
Let me ask you, I thought after these controlled buys, the informant goes in, gives him $650, whatever it was, gets a half ounce of cocaine, comes back out. He no longer has the buy money, but he has cocaine on his person. He was searched before he went in. So where'd that cocaine come from? You're not attacking the sales that occurred at St. Bernard, are you?
No.
Oh, okay. Maybe I misunderstood what you said, because the controlled buys, they search the guy, apparently wire him, give him the buy money. He goes in, comes back out, buy money's gone. He's got a little packet or whatever, half ounce of cocaine on him. So maybe I misunderstood what you said. I thought you were attacking the purchases at the Vine Street as not being legitimate. Did I misunderstand what you were saying?
You did.
Okay, all right. So you can disregard the question.
There are two control.
Yeah.
There are two control buys in this case.
Okay. Right.
The point is, there is nothing that connects that location. In fact, one would, I think, argue that he has gone from the place where he lives, keeping all that noise away from his home, to go to somewhere else to do his business.
Let me ask you this, Mr. Cohen. Getting back to the probable cause determination in the search warrant, it appears that the trial court disregarded the training and experience of these police officers. And, we've been over the case law, what's necessary to be shown. But in this affidavit, looks on page 7, it says, detectives have maintained electronic and physical surveillance on Lang since July 21st, 2021. Lang has established a pattern which indicates his primary residence is 6014 St. Martin's Place, Cheviot, Ohio. Lang spends overnight hours at the aforementioned address, generally leaves the address between 1:30 and 3 p.m. and proceeds to the Vine Street address. Now, this is the part. Detectives believe Lang disassociates himself from St. Martin's address to conceal his narcotics trafficking from law enforcement and rival drug dealers. Based on your refine's training, knowledge, and experience, it is common for individuals who distribute illegal narcotics to utilize vehicles and residence of others to further their legal activities, which that last part of that paragraph seems to track what this case law says. At least that there's an acknowledgement that people use their residence to store money, guns, dope, whatever, and to disassociate that residence from where they're actually trafficking. And that's right here to me, it looks like the judge wholly discounted the training experience of this affiant. And how would you address that?
Well, I don't necessarily agree with that interpretation. She's indicating they separate from their one life where they use other residences and other locations, cars, et cetera, to sell drugs. Nothing in that statement by the court indicates that they're definitely hiding stuff at the place where they live. Now, again, that's where we're asking for some evidence. And that's what we don't have, and that's what that's what the case law says.
Seems like that evidence was good enough in the other cases, though.
Well,
so how would you differentiate it if the officer tracks that language from those cases?
The issue is nexus, whether there is a connection between the criminal conduct and the place to be searched. Training experience is wonderful, but stand where I stand, where we stand as defense attorneys all the time, where we will read an affidavit by the same officer who will write separately in different search warrant requests. The particular suspect, we know that drug dealers always have a special spot, where they deal drugs out of, so we can search anywhere they've gone or their lockers. Or the same officer will say, well, we know that they have a special spot, but they always keep stuff in their home. it's an issue of convenience, whatever serves the purpose on that particular request for a search warrant. But Nathanson says that it is not the subjective belief of a police officer, despite training and experience. It's the objective evaluation of whether or not there is some evidence which ties the individual and the conduct to the place to be searched.
And Mr. Cohen, you were past your time.
I know I am. I apologize. Thank you.
We asked you a bunch of questions. It's fine. Great. Thank you. Mr. Sutter, you have 6 minutes.
Yeah, Your Honor, it's just a brief factual point. I've gone through the affidavit again last night, and I don't see any indication there where it indicated that he ever spent the night at the Vine Street location. A small point, but it's something that the record will reflect one way or the other. To Judge Winkler's point, they don't have to be drugs at the location that they're searching. It's as indicated by Detective Ingram, as indicated in the case law. It's there is at least an indication that there would be proceeds, records, some other indicia of criminal activity that would be at the residence. And
Counsel, I have a question about the GPS unit. Mm-hmm. I'm making an assumption here, please correct me if I'm wrong, that because the GPS unit was placed on a vehicle, that there would be daily a log or something of the back and forth movements of this person. Right. And that information does not appear in the affidavit.
It's not, Your Honor, but I think what we have to focus on is this is a probable cause determination. It's not a question of guilt beyond a reasonable doubt. And I think that the movements that were demonstrated in this case is clearly enough to demonstrate that there's a fair probability that there would be evidence found at that location. And I think we're trying to, if we try to poke holes in these warrants, I think we kind of miss the point of the deference.
Well, but I think like there's like what if every evening after he got done at the Vine Street location, he went to a warehouse or to a boat on the Ohio River, like, somewhere that you could think that there would be drugs, then that might make it look less likely that information might be at the residence.
I think it might, but Judge, I think, what we have to look at is the evidence that was presented to the issuing magistrate.
Well, but that's what I'm talking about. Like, could you shore up the affidavit by excluding evidence that might point in the other direction?
Yeah, and I think there are always things where you could, after the fact, say, well, we should have put the log in from the GPS. But I think that even beyond the pattern that was demonstrated, I think the courts have recognized that a person's residence has a special significance in the drug dealer's world, and that the Fourth District might not be a bastion of scholarship, but if it's good enough for an appellate court, it's good enough for a police officer to rely on. But on that point,
doesn't a person's residence also have a special place under the Fourth Amendment? I mean, we're talking about searching somebody's house.
It does, Your Honor, but I think in terms of whether or not probable cause has been demonstrated, we're still requiring probable cause to search, and I think that that's the protection that we give a residence, and I think that protection was given in this case.
And can you summarize briefly for me where the probable cause comes from?
I think the probable cause comes from the fact that there's a known drug dealer who has a pattern of going from his residence to his place of business and back again. And I think based on that, the case law indicates that such a pattern of movement, and along with the knowledge of how drug dealers operate, would indicate a fair probability that there would be evidence found at that location.
Thank you.
You're welcome. Unless the court has any questions.
No, thank you.
Thank you.
Thank you both for your arguments this morning. The case will be submitted. We'll get out a timely written decision. Hope everybody has a great day.